Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and good afternoon to Dr. Arif and my fellow friend. We are from Group 1, and for today we are going to present on the topic freedom of association, political stability and the prospect of anti-hopping law in Malaysia. Okay, I will introduce our group member first. There are Muhammad Hifni bin Muhammad Zulkifli, Nur Amalin Husna binti Muhammad Nadzir, and last but not least, my name is Wan Nur Amirah Zahidah binti Wan Anuar, and my metric number is 1202180. Okay, today I will talk about freedom of association that can be seen in the Article 10, Clause 1, Paragraph C of the Federal Constitution. Okay, first of all, Article 10, Clause 1, Paragraph C stated that all citizens have the right to form associations. However, they are subject to restriction because it is deemed necessary or expedient in the interest of the security, public order, or morality, such as Societies Act 1966, Trade Union Act 1959, and Universities and University College Act 1971. Besides, there are also restrictions on the right to form associations may also be imposed by any law relating to labour or education. Moreover, Article 10 obviously stands at the centre of the democratic process as it is codifies basic common in all democracies, and the rights provided by the Article 10 is central to democratic process because without this right it is difficult or even impossible for us to have a functional and healthy democracy. So these are the rights that would preserve the peaceful and non-violent way of changing government. Alright, as we move on to the next slide, according to the Section 2 Trade Union Act 1959, to forming and registration of a trade union, the following steps should be complete. Any group of 7 or more workers can form a trade union providing they work in the same trade, occupation or industry, and the intended membership all work either in the private sector or all in the public sector. Firstly, once a decision is made to form a union within a month, the application of registration must be made and all unions are required to register with the Director General of Trade Union in order to operate legally. After that, they must apply to the Director General within 1 month of establishing a trade union, but they may ask for extension of 6 months. Then, the complete application form signed by at least 7 members. In addition, the application form must be accompanied by the required fees and printed copy of the rules or constitution of the union. And furthermore, the application must include the name of the union and its address. After that, the names, addresses, and occupation of the members who are making the application along with the union's officers should be mentioned on the application. Last but not least, Director General may require other information such as a copy of the MOI meeting of the workers who wish to establish the union or etc. Okay, now I will explain about the competency check. Okay, competency check in the recognition process was outlined clearly by the court in the case of Minister of Labour and Manpower and Patterson Candy M. Sudirman Berhad. In this case, the court held that the workers must be within any similar trades, occupations or industries as written in the trade union's constitution. This was done in order to curb communist influence so that we can ensure nation's harmony. Okay, next is in the latest case of Kesatuan Kebangsaan Pekerja-Pekerja Perusahaan Alat-Alat Pengangkutan dan Sekutu and Menteri Sumber Manusia and another, the workers' right to be represented by a national union was denied on the grounds that the workers did not belong to a similar industry within the scope of the union's constitution. This also was done as a precaution in ensuring our nation's harmony. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Amalin Husna and my metric number is 1202181. Okay, so we are going to take a look at the status of political stability in Malaysia. Before we go into that, we need to know the indicators of to have a politically stable state. Okay, so the first one is to take a look whether the state will have a good governance or not. It is by looking into the quality of policy formulation and implementation or public sector agencies' commitment to achieve the intended outcomes and credibility of public institutions to provide quality of public services. And then the second one is the absence of violence or terrorism that measures the perception of the likelihood that the government will be destabilized or overthrown by unconstitutional or violent means, including politically motivated violence and terrorism. We move on into the issues that cause instability in Malaysia. So the first event is about Sheraton move. This happened in less than 18 months amidst the pandemic of COVID-19, where, as we know, it has caused the rising of the public anger. Okay, this operation was popularized by the media as the Sheraton move because the renowned hotel in Petaling Jaya was made the main headquarters of the power transition. This event is where the members of parliament or the MPs changing party support, leading to the loss of public, to the loss of parliamentary majority, the collapse of two successive coalition governments, and resignation of two prime ministers in less than 18 months. Okay, it saw the ousting of the elected Pakatan Harapan government and the resignation of Prime Minister Mahathir Mohamad after 22 months in power. The collapse of two successive governments is one Mahathir cabinet and then the Muhyiddin cabinet. This is due to the political infighting within Pakatan Harapan and Perikatan Nasional. And then the second one is the case of Niza and Zamri, which is the first case of executive transition through the palace. This case was brought by Menteri Besar of Perak State, which is Muhammad Niza Jamaluddin, against Zamri Abdul Kadir, who acted as Menteri Besar after three members of the State Legislative Assembly defected from Niza's Pakatan Rakyat and threw their support behind Zambi's Barisan National Coalition. The subsequent confusion and controversy regarding the state government resulted in the 2009 Perak constitutional crisis. The federal court bench found that the Court of Appeal was justified in reversing the High Court decision, which had earlier declared Muhammad Nizar Jamaluddin as the rightful Perak Menteri Besar. So, the conclusion here is the federal court ruled that Zamri to be a lawful Menteri Besar in Perak. So, what will happen to the state if there is political instability? So, the first one, the state could be unable to forge or put together a coherent response. Malaysia's response to COVID-19 is being hampered by chaotic governance and persistent political infighting, with Parliament suspended since January due to a controversial national emergency declaration. Political leaders and public health officials have been unable to forge a coherent response to the COVID-19. So this could endanger Malaysians' public health due to the act of the government who prioritize political power over a focus on public health. Then the second one is it brings harm to the economic performance of a state. Okay. Following to the resignation of Mahathir Mohamad, Malaysia's stock market dropped to its lowest point since 2011. The ringgit also weakened against US dollar. Okay, so this also happened during Muhyiddin Yassin's resignation. So that's all from me. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum and a very good afternoon to Dr. Arif and fellow friends. My name is Muhammad Zulhifni bin Muhammad Zulkifli. My metric number 1203189. So for today's presentation, my part is to explain further regarding with the prospect of anti-hopping law in Malaysia. Let's move on to the first part of the prospect of the anti-hopping law in Malaysia, which is the definition of party hopping. According to Wan Junaidi Tuanku Jaafar, a minister in the Prime Minister's Department, Parliament and Law, three criteria qualify an action to be considered as party hopping, which contained in earlier draft of the anti-hopping bill. Which is the first one is when a member of Parliament announces that he is leaving the political party under which he contested in election to become an independent member or to join another political party. So the second criteria is when a member of parliament is expelled from his or her political party and joins another party. So for the third criteria is when an independent parliament when an independent member of parliament joins any political party after winning in an election. All right, now let's move on to the history of party hopping in Malaysia. In the past years, requests for anti-hopping law to prevent elected representatives from jumping ship have mostly gone neglected. Assemblymen from Parti Bersatu Sabah (PBS) defected to Barisan Nasional (BN) during the 1994 Sabah state election. The term frog was used to refer to the member of parliament and assemblymen who involved in party hopping, which later resulted to the collapse of the Sabah government. More cases of party hopping have arisen over the years. As many as 40 members of parliament switching sides, involving in infamous Sheraton move, which in Malay we call it as Langkah Sheraton, in 2020, which later contributed to the fall of the Pakatan Harapan government after only 22 months of tenure. I mean 22 months in power. Next, about the political instability also occurred, which Yang di-Pertuan Agong has to select two prime ministers in 2 years as the federal government changed twice. And also the Pakatan Harapan and the government signed a memorandum of understanding to restore political stability following a government change. And one of the terms required the government to pass anti-hopping law in Malaysia. All right, now let's move on to the most vital, most important things with regards to the prospect of anti-hopping law in Malaysia. So, what is anti-hopping law? An anti-hopping law is designed to prevent persons who are elected under the ticket of a political party from crossing over to another political party after winning a seat. Party hopping is obviously deemed problematic and a betrayal of voters' mandate. A lawyer Bastian Pius Vendergon said people suspected that party hopping was usually done for personal gain and at the expense of the voters, many of whom vote along party lines. However, the reason of party hopping has not been made illegal, has been made outlawed is because of the federal court declared in 1992 if this anti-hopping law is being passed, it would infringe upon one's freedom of association, which has been stated in Article 10, Clause 1, Paragraph C of Federal Constitution. All right, now, as all of you have seen the in the slides, there is a question which is it necessary for anti-hopping law to be enacted in Malaysia? So as for me, I would say that yes, it is very necessary for anti-hopping law to be enacted in Malaysia. Why? Actually, uh, it can preserve long-term political stability. Why? The people actually continue to have trust and confidence in the country's democracy, which allows the people to vote for the elected representative. So if party hopping law is left unchecked or left behind, it would be very difficult for Malaysia to have long-term political stability. So the consequences of the political instability is it can lead to other problems which can severely affect everybody's life, in which foreign investors will avoid investing in our country. Thus, consequently, it may affect economic performance and also job opportunities, which eventually lead to an increasing number of unemployed people. So that's all from me. Thank you.